All right.
Yes, sir.
Is it fine?
Now we can hear you, sir.
Okay.
Thank you so much, sir. Please go ahead.
Thank you. Good afternoon to everyone. So as the sir has already highlighted the topic assigned to me, the child abuse legal provision in India. Well, before we discuss on the legal perspective on the child abuse in India, first we need to understand that the issue of child abuse is not only confined to India, in Indian context, but it has become the global issue, and it has been appreciated by international community as a whole in the world. So in this connection, the global movement for criminalization of violence against the children was formally began with the formation of United Nations Convention on Children's Rights in year 1989. And this convention was later on ratified by the India in year 1992, whereby India became one of the members amongst the international community to be a part of UNCRC, that's the United Nations Convention on Children's Rights. Under that convention, the Article 49 emphasized for setting up or establishment of separate juvenile system in all the members of the convention, in which India is a signatory. Therefore, India, being the part of the convention, is bound to take up all sort of measures and steps for the protection of the children and to safeguard the interests of the children and protect them from the abuse, any form of abuse. Therefore, to uphold the provision of international treaty as under convention, India has enacted, of course, other acts also there, but India has enacted two major legislation. That is, first is I would like to discuss on the two aspects, two legislation. And the first I would like to take up on the Juvenile Justice Act. Initially, the Juvenile Justice Act, in consonance with the provision of convention, first Juvenile Justice Act was enacted in year 2000. But later on, during the course of implementation, it was found that the provision incorporated under 2000 Act, Juvenile Justice Act, were found to be ill-equipped and inadequate to deal with or tackle up the increasing issues of the children. And it was 2000 was repealed by way of new act that is called Juvenile Justice Care and Protection of Children Act 2015. This act, it's covered of entire safeguard and exhaustively for protection and to safeguard the interests of the children and to protect them from any sort of the child abuse. The silent features of Juvenile Justice Act 2015 are to provide for general principle of care and protection of the children, to provide procedure for children in case of education and social and so on. The all exhaustive, this has to be under 2015 Act, all the angle has been taken care of. So under the provision, the provision for our discussion is, I would like to mention certain provision which is relevant for the purpose of discussion. Under 2000 Juvenile Justice 2015 Juvenile Justice Act, it has been made as mandatory under section 32. It has been made mandatory for every individual, any individual of the society, to report. Suppose suppose we happen to be in the anywhere, maybe in the hospital or maybe in anywhere in any institution, and if we happen to come across any child who seems to be or appears to be separated from the guardian or lost, or is appears to be orphan without support of the child or without support of the guardian or family member, in that situation, it has been made a mandatory, obligatory upon the person concerned to inform about the such child to the concerned authority. That is either to the child helpline service or child welfare committee or juvenile police unit and so on. It has become mandatory. Likewise, the same in the hospital, other institution, everywhere. The in charge of that, the organization, institution, is duty bound to report the same to the concerned authority. Now, the question is, in case if person neglects doing so and defaults in reporting such information to the concerned authority, now what would be the consequences for act of such omission? Now, under this Act, 2015 Act, such act of omission on part of the individual concerned has been made as a offense, criminal offense, for which person concerned can be punished if convicted up to the imprisonment up to 6 months with a fine. That is under the specific provision under section 34 of the Juvenile Justice Act 2015. Therefore, whenever the child's found seems to be neglected or lost from separated from the guardian, it has become the bounden duty of every citizen of this country to report a matter to the concerned authority for immediate action. Now, apart from this part, Chapter 9 of the Juvenile Justice Act 2015 talks about or deals with the certain other provision offense against the child. There are so many. Entire the issue related that has been incorporated or enumerated under Chapter 9, including child labor and so on. And from their most important for our discussion, I would like to highlight on a section 74. The section 74, it prohibits any person from making disclosure of the identity of the child. In other words, suppose the child is found to be conflict with the law, child in conflict with law, or happen to be child the need of care and protection, or victims of any abuse, or witness, maybe connected to the any crime, if you happen to be witness. It is a bounden duty and statutory duty that we should not disclose the identity of that child. This is with view to maintain and respect and protect the privacy of the children. Now, however, there's a certain exception to this provision. Say, suppose if such publication or disclosure of identity become the utmost interest, the larger interest for the benefit for the child concerned, then in that case, his identity can be revealed or published with prior permission from the concerned authority, either from the court or from Juvenile Justice Board and Child Welfare Committee, with that prior approval is required. If it will examine
recording in progress.
Now, in case of violation, suppose the identity of the child is revealed without prior permission, then it's constituted a criminal offense, for which person concerned may be punished with the imprisonment up to 6 months and with a fine of 2 lakhs. This is the revealing of for the purpose of revealing and disclosure of the identity. That's a punitive section has been incorporated under this latest Juvenile Justice Act 2015. Now, there are also other various provisions like child labor. We cannot keep the child in the home for the purpose of which for the employment purpose and all. This is all the offense now become the offense by the new act. And the cruelty to the child, this even abusing or neglecting the child, it's constitute the offense of cruelty, which is punishable under the Act of 2015. Now, one new point, provision that required to be mentioned in this discussion is corporal punishment. In previous, the Act 2015 Act, 2000 Act, initial Act, this corporal punishment was not there. Corporal punishment is a kind of a punishment imposed upon the child with a view to disciplining them or disciplining him or her. Usually it's happened in the institution, school, or somewhere at the child care center. Now, by new Act 2015, such corporal punishment has been made as an offense for the purpose of, even for the purpose of discipline. The child concerned cannot impose such corporal punishment to the child, and on violation of such provision, in case if happen to impose such corporal punishment, especially that person can be, in case of convicted, he can be sentenced to the 3-month imprisonment with fine. And not only that, if he is found to be convicted, his service shall be dismissed. Is to be dismissed, not only dismissed, but thereafter will also make reward that make sure that they will be diverted from re-employment anywhere in the country or the state, in the state, relating particularly area where the the child care service is being rendered. They cannot employ, re-employ anywhere related to the field where they are required to deal with the child or children directly. That is prohibited. And the comprehensive legislation has been brought in this 2015 Juvenile Justice Act. Now, thereafter, another major legislation in India enacted by the Parliament in consonance with the provision of international treaty, that is United Nations Convention on the Right of Children, is popularly known as the Protection of Children from Sexual Offense Act 2012. In short, POCSO Act. So the prime object of this POCSO Act is to protect the children from various sexual assault, sexual harassment, and other such unlawful activities, sexual activities, such as involving the child in pornography and showing all those things. The POCSO Act deals with exploitation and all. Now, under this POCSO Act 2012, Chapter 2 of the POCSO Act basically deals with certain categories. The general 5 categories were the offense, which is serious in nature. The first categories of the offense under POCSO Act is penetrative sexual assault. Under this act, under this provision, if any penetration is committed by any person against the child, any person is, but here other than servant or here we're talking about the individual. If the individual concerned other than servant, then such offense is punishable up to 10 years, not less than 10 years, except to life imprisonment. Now, if assault is committed, police officer, jail authority, the person in charge of the institution, organization, including hospital authority, either public or private. So if such penetrative sexual assault is committed, then it is called aggravated penetrative sexual assault. And for that, such offense, for the offense committed by such authority, it is punishable not less than 20 years or death sentence. This is how the penetrative sexual assault under Chapter 2. The sexual assault, it has also been, the offense has also been categorized. In case of sexual assault, that is touching the private part of the child's with penetration, that is called sexual assault. That's also if it's done by the private individual other than authority, or public servant, then punishment it is it's not less than 10 years. But in case of sexual assault by the private, it is up to 3 years, but extendable to 5 years. But in case if such sexual assault is committed by the person and authority, like police officer, jail authority, the institution in charge, hospital authority, and all, if it's the committed by such officer or such the authority, then it is called aggravated sexual assault, liable to be punished 7 years. Now, the other offense under 2 of the POCSO is against sexual harassment. What is sexual harassment? Sexual harassment, even mere showing any object to the child in the form of video, pornographic video, and enticing the child to involve in for the purpose of pornographic, enticing them kind of gratification. This all comes under sexual harassment. And even for that also, for a commission of such sexual harassment, it is liable for the in case of the offense committed, it's liable for imprisonment for 3 with a fine. Now, apart from that, all the basic offense, the POCSO Act, the most part is as like that of Juvenile Justice Act. Here, the POCSO, there's also provision, citizen, that it is become the mandatory under Section 19 of the POCSO Act. It is mandatory for any person with the society to report whenever there's any offense against or sexual abuse against the child. It's become the mandatory and the bounded duty of every individual to report such matter to the concerned authority without unnecessary delay. And likewise, the information that is even equally applies to the authority, even hospital or in institution, everywhere. Now, in the institution it's happened or hospital where it's happened, the person they're part to report the matter to the authority for immediate action. Because in case of non-compliance provision, in case if they do not report it, then the such act of omission on part of the person concerned constitute the criminal offense, and for which they are liable for punishment up to 6 months for such act of omission on part of the person. The POCSO is I feel it's relevant for most important relevant for today's discussion, is the provision relating to the medical examination of the child. Under Section 27, it says that whenever the victim of whenever any victim or the sexual is brought to the medical, either in the private clinic or the government hospital or wherever, when such patient is or victim is brought to the such center, it is the bounden duty of the attending doctor or staff or nurses to attend them first and provide all possible treatment, first aid to the victim, that too on free of cost. Because the last recent past, we have seen that whenever such the matter or the patient is brought to the hospital, the attending doctors or authority, what they used to say in the recent past, that since it is related to the police case, criminal case, first the case they should go to the police and get registered the complaint, and they should come along with the police for the further treatment. Now this is not to be done. Now this all the procedure, this thing that was creating confuse, that has been made clear that whenever such the victim is brought to the hospital, it's become the bounden duty of the attending doctor to give first aid, irrespective whether there's any case registered against a complaint made to the authority concerned. Irrespective of that, first one has to attend the patient, give all the medical aids, the treatment free of cost. So in view of this section 27 of POCSO Act, the principal act of the criminal procedure, that is called Criminal Procedure Code 1973, was also amended by way of Amendment Act 2013, whereby the specific provision, section 357C has been inserted as per the 357C CRPC. All the hospital, either run by the public or the government hospital or a private or any person, private clinic, the same as the provision as laid down under 27 of the POCSO Act, that they must attend the patient and must give the treatment, all possible treatment, and must inform the incident to the authority. When if the case has not been registered, a complaint has been lodged, then after attending the medical treatment, this is become the duty of the attending doctor to inform the authority concerned, that is police officer or whosoever may be, a child care protector, whatever, whosoever may be. That is the duty of the attending doctor to inform, and we cannot wait that the person to come, and the treatment cannot be avoided. Now, in case if this does not done, or this provision is not complied with by the person concerned or by the attending doctor or the staff, then there's the further punitive section has been incorporated by way of Amendment Act 2013 by amending the Indian Penal Code, IPC. The IPC in 2013, the section 164 was inserted, which is a punitive section for those the attending, those doctors or the medical staff who does not comply with these provisions, the giving treatment, the giving first aid to the victims of sexual abuse, or they do not attend. In that case, it's become again punitive section, and that is a punishable offense for act of omission under the IPC. And under that provision, the person is punishable up to 1 month, not 1 month, after 1 year of imprisonment with a fine. So with the coming of this two major legislation in India, that too in consonance with the provision of international treaty. Now, the ample safeguard has been provided in India to safeguard the interest of the children and protect the children from the sexual abuse or any form of the abuse. And I personally feel that by enacting these the legislation in India, India could extend its obligation to the most possible way for the benefit of the children. Nevertheless, for better and effective implementation of this act in letter and spirit, I feel that a special, the orientation or workshop program should be conducted from time to time to train and educate those, the implementing agency, the authority or functionaries, to sensitize them their role and function under a statute to safeguard and protect the interests of the children. And with this, I conclude this presentation on the legal provision. Although there's the legislation also there, but for me, I feel that it's the only relevant part to be discussed today. Thank you.
Thank you, Taba Tagum, sir. Briefing about existing legal policies in India against child abuse. And it clearly described the fundamental rights, the details of Juvenile Justice Act of 2015, the direct principles of the state policies, acts, and amendments, and other constitutional provision against the child abuse.